Hi, good day. My name is Daniel Claman. I'm a supervisor in the money laundering and asset recovery section of the U.S. Department of Justice. I want to start by thanking IBF for the opportunity to moderate this panel of distinguished experts to discuss the timely issue of domestic and international cooperation in anti-money laundering and financial crimes and asset recovery. Working myself in international financial crimes enforcement for the last 20 years, I've seen an exponential increase in the number of cases that turn into multi-jurisdictional investigations with parallel prosecutions and confiscation actions, as well as victims across different national boundaries around the world. What used to be really mainly a fight against transnational narcotics organizations now involves multi-billion-dollar fraud schemes, the urgency of combating terrorist financing, and a critical emphasis now on stemming the disastrous effects of grand corruption or kleptocracy, which is at the core of my own practice. We need effective institutions, laws, and collaboration amongst all of us in both the private sector and the public sector and between public and private sectors to identify and take action to combat these criminal threats. Fortunately, today we have a panel of experts with a very diverse background to give us a different range of perspectives on this very broad topic. First, we have Martina Link. She's a vice president of Germany's Federal Criminal Police, the BKA. She comes to us with over 30 years of experience as a case officer, a supervisor confronting organized crime and other offenses, a divisional head of operations and investigative support, and now in a senior leadership role responsible for some of the key strategic decisions of the BKA. Next up, we have Dr. Martin Bozet. He's a distinguished legal scholar and professor at the University of Bonn, specializing in international and comparative criminal law. Among his many accomplishments, he has written and lectured extensively about criminal law and procedure, human rights, and other matters, including harmonization of international legal standards, which is so important in this effort to address international cooperation. In addition, he's represented the German government before the German Constitutional Court and has served as a criminal law expert in Parliament and for the negotiation of a multilateral instrument on the illicit tobacco trade. Elia Minari, it comes to us from Italy. He's a private attorney who has a vibrant practice working with law enforcement as an expert on organized crime, the Mafia, corruption, and many other matters. Over the last 13 years, his work has assisted several criminal prosecutions at a variety of different stages, including with evidence presented in court. He's also a regular consultant to police authorities and a lecturer for universities, law enforcement, local governments, and communities, all of them trying to find ways to combat and prevent organized crime and corruption from affecting their communities. And finally, but of course not least, is Jean-Pierre Brun. He's an expert on financial market integrity and asset recovery at the World Bank. He's a key member of the Stolen Asset Recovery Initiative, which is a partnership between the World Bank and the UN Office on Drugs and Crime that assists countries in recovering the proceeds of corruption. His work providing technical assistance around the world gives him great insight into the many different challenges that different countries face in investigating corruption and financial crime. He's served as a French prosecutor, a French investigative judge, a director of investigations for Deloitte, and as a government auditor in his extensive career fighting financial crime. So I'm sure his experience will be a great addition to the panel. So with that very brief introduction, I wanted to start off our discussion with Ms. Link, and hopefully she can give us a little bit of an idea of the role of the BKA in criminal prosecutions and the fight against international crime. It'd be helpful to hear a little bit of what some of the most important developments have been in the last 3 to 5 years. So with that, hopefully, I'm sorry?
I'm sorry, I can hear you, but I can't see anybody. Or you can't see me because we have problems with the camera. I'm sorry about that.
All right. Well, do you want to go ahead, or should we?
We could start. Yeah, we could try it without camera. Maybe we got it in some minutes. We try to it, okay?
Fantastic.
Yeah, okay, thank you. So I shall start now?
Yes, please.
Okay, thank you. So just coming to the task of the BKA, as you may know, Germany is a federal republic, and for that the federal states are responsible for police matters in principle in Germany. But of course, there are also federal police agencies like the BKA, Federal Criminal Police Office. And BKA is the central office of the criminal German police, and our main tasks are coordination of national crime control and collection analysis and routing of information. We are the central office for international cooperation, and this also includes political counseling. And what is also important that we have a task of criminal prosecution in several fields of national and international crime. And in particular, it's the criminal prosecution in international organized crime and international terrorism, and also including money laundering in such cases. And coming to the field of money laundering, what we do is investigations in very complex cases. We conduct complex investigations, especially if they are attributed to international organized crime for suspected money laundering or terrorist financing, inter alia, by our police and customs joint financial investigation group. And we also run operational analysis, and we conduct some analysis projects. So that's a short overview over the task of the BKA within that area. And to have a view on the developments over the last 3 to 5 years, I think what is most important is that we are on an ongoing process on harmonizing our legal frameworks, especially within the European Union. There are several money laundering directions of the European Union, which support national states to implement legislation in their national framework. To say, for example, there's an implementation of a central transparency register, which is a register on beneficial owners of companies, trustees, of associates and foundations. And this will be connected with other national registers within the European Union to help us to identify people and companies. And one second important development on European level is that there have been set due diligence and reporting requirements for service providers for the custody management and safeguards for crypto assets. And we also try to implement the so-called travel rule, which is part of a recommendation of the FATF. So in the course of a crypto transfer, the details of the payer and the beneficiary of such a transaction, they are exchanged between the crypto custodians. And also in a case of a transfer to or from a private wallet, the identity of the owner is identified then. And what we also have is very good and very established structures of information exchange on national, on European, but also on international level between law enforcement, between supervisory authorities and the private sector like finance sector, but also non-finance sector. There are several groups of cooperation where we were very close and very successful together. With a view to Germany, I would like to mention that we had in 2017 an adoption of the asset confiscation, a new adoption which gave us the possibility for the independent confiscation, which means that it's not necessary to prove a concrete offense to confiscate unlawfully acquired assets of unclear origin. So this makes it very easier to confiscate illegal money. And a very new development, brand new, so to say, it's the amendment of the punishable offense of money laundering in Germany. We now have the so-called all crimes approach. So it's not necessary to have a special predicate offense, but all possible crimes can be predicate offenses of money laundering. So that might be a short overview over the most important developments concerning Germany and European Union over the last 3 to 5 years.
Wow, that's quite a long list of different things, and I think it's important to note that I think both institutionally it sounds like you have the organizational structure that tries to foster cooperation, specialized areas that focus on specific threats such as organized crime, and then many new developments, both legislatively and through international cooperation. One sort of brief follow-up question I thought I would ask is on this issue of the Central Registry of Beneficial Ownership. I know that that's certainly a challenge for law enforcement and for financial institutions as well as they attempt to know their customers. Is that something that's available or going to be available to law enforcement authorities and regulators, or is it also going to be available to the private sector, meaning the financial institutions, as they try and comply with their know your customer obligations?
I'm not sure if the finance sector has direct access to that registry. Law enforcement has, but I believe that also the finance sector has the possibility, but I'm not sure, sorry.
Okay, thank you. I think next I'd like to turn to Dr. Bose. It's certainly in my practice in asset recovery and corruption cases, the ability to translate our actions in the U.S. to actions in other jurisdictions is very important. And I wanted to ask him how the EU legislative initiatives, such as those requiring mutual recognition of arrest warrants or confiscation judgments, has helped law enforcement and prosecutors fight transnational crime.
Yes, thank you very much. The principle of mutual recognition in the EU is a cornerstone of cross-border cooperation. But mutual recognition does not mean automatic execution of judgments, arrest warrants, and so on. And I think that's a quite important point. If you just hear the term recognition, you might assume that there is a kind of automatism in execution, and that's clearly not. So there are still a lot of parallels to the traditional regime of cross-border cooperation. But of course, there are important differences that significantly facilitate cross-border cooperation between EU member states. And what are these differences or features facilitating cooperation? First of all, we have a judicial procedure. So the political level, the government, is usually completely out of the proceedings, and that significantly speeds up proceedings. Furthermore, we have strict time limits and standardized forms. So information which has formerly had to be incorporated in requests has to be contained in forms. So we have a standardization that also speeds up proceedings. And then, which is the most important feature, is that we have restricted the list of grounds for refusals. I think that's also a very important, an important issue. We have an obligation to cooperate, an obligation to execute, and an exhaustive list of grounds for refusal. And this, of course, in sum, leads to a significant facilitation and enhancement of cross-border cooperation. Just to give you an idea, the first legislative instrument implementing the principle of mutual recognition was the European arrest warrant, replacing traditional extradition. And in Germany, before that instrument, extradition proceedings within the European Union usually took, in the average case, about a year, 12 months. So under the new regime of the European arrest warrants, it's just 2 months. So I think this already shows that proceedings have been facilitated and speeded up by this new instrument. And the scope of, well, or the number of cooperation instruments based on this new principle has grown over the last years. And since 2018, we have also a regulation on the mutual recognition of confiscation orders and freezing orders, which most recently entered into force by the end of 2020. So there is there are not much cases yet, but the experience with the European arrest warrant and other cooperation instruments, well, gives rise to the expectation that proceedings and cooperation will be facilitated under this new regime as well. But of course, we have some specific difficulties in the area of mutual recognition of confiscation and freezing orders, because we still have, even in the European Union, a variety of different concepts of confiscation. So there has been accompanying legislation on the harmonization of these different concepts. But, well, I think in this regard, there's still some work to do. But of course, it's progress in this area, important progress. So thank you.
Thank you. That's really exciting. I know that just hearing about the difference in extradition from going from a year to 2 months is quite startling in what kind of a dramatic effect it can have. And certainly, I hope the same is true in terms of enforcement of judgments. Most multilateral treaties on criminal law now have a provision for mutual recognition of confiscation judgments, but they're hard to do in practice. And so we look forward to learning more about how the EU is able to innovate in that area. Know that in the United States we do it, but we have our own difficulties in finding efficiency in accepting foreign orders and translating them into something that our courts can enforce. So that's fantastic. I'd like to turn to Mr. Minari to tell us about the important role of the use of data and in transnational investigations, and more about his work in confronting the very real and difficult challenges of fighting organized crime in the Mafia. So, Mr. Minari.
Good afternoon, ladies and gentlemen. I would like to thank President Maleki for the invitation, and I would also like to thank the forum collaborators. I think the use of databases and the interconnection of open source information are essential for international judicial cooperation. For the past 13 years, I've been using a new method. This new method is based on cross-checking of databases and is more innovative use of open source information. This method, which I've been applying for the past 13 years, has contributed to carrying out criminal prosecution investigations against organized crime in northern Italy and against cases of money laundering and corruption. My investigation focused on the 'Ndrangheta Mafia, which originated in Calabria in southern Italy. Today, the 'Ndrangheta Mafia is making investments in key business sectors in 16 countries of the European Union, as well as other important countries. The 'Ndrangheta is the only mafia organization with a presence in every continent. The 'Ndrangheta is responsible for money laundering and corruption. The 'Ndrangheta Mafia is a multinational company of crime. 'Ndrangheta's turnover is estimated to amount to 53 billion euros a year. The investigations I've carried out over the past 13 years were used as evidence against the 'Ndrangheta in court. Anti-mafia prosecutors asked for permission to use some of my investigation as evidence against the mafia again last month, and the criminal judge agreed. The 'Ndrangheta is now the most powerful mafia. It is therefore crucial to take actions to prevent and fight against the 'Ndrangheta in order to protect the economy and finance. The 'Ndrangheta Mafia is a criminal organization actively involved in economic investments. My investigation method is based on analysis of economics relationships investments, and the connection between companies. Analyzing companies' financial statements and documents is crucial to unveil link with the money of criminal organizations. It is possible to uncover some existing relationship, although they are hidden behind the shell companies. In addition, the method I conceived demands connecting the elements I've just mentioned with information on public procurement and other investment, such as in real estate. These innovative investigation methods are complementary to traditional methods, which remain essential. The interconnection of databases on companies, real estate and land properties, cars, and the use of innovative method to cross-check this information can be very useful to limit the expansion of the 'Ndrangheta and other organized crime groups that invest in the market. For these reasons, I conceived a new method. It is critical to reduce the power of organized crime groups, especially in this time of pandemic. Criminal organizations know how to adapt to changes. In recent months, 'Ndrangheta-owned companies have offered money to entrepreneurs who are experiencing financial difficulties due to COVID-induced business inactivity. 'Ndrangheta gives the illusion of helping struggling businesses and promises wealthy entrepreneurs they will easily get even richer. 'Ndrangheta gets into new markets with its huge amounts of money and corrupts people. In addition, the 'Ndrangheta Mafia during the pandemic set up businesses in new sectors and specialized in sanitization, medical waste disposal, and medical device manufacturing. A number of arrests for these offenses were made in Italy, and 'Ndrangheta proved itself able to change and adapt to new needs. It is important to inclusively develop innovative investigation method also by taking advantage of a currently available technology. This method enables to uncover even white-collar crimes. It is impossible for a criminal entrepreneur and for a professional to leave no trace at all for the offenses committed. So we need to be able to identify and understand these traces. In order to spot relevant elements, we need to have a deep knowledge of current crime trends and to be able to recognize clear signs without getting lost in the mass of information. Therefore, I conceived and developed this new method that was found useful by judges in Italy and law enforcement for investigation into 'Ndrangheta and criminal organization. Everything must always be based on facts, resulting from careful and thorough checks, not suspicion. The use of databases and open source information is important. 'Ndrangheta is investing more and more money in affluent areas such as Milan, suburbs, in northern Italy, and other countries. In Germany, 'Ndrangheta has made a significant investments in companies. 'Ndrangheta operates through entrepreneurs who are above suspicion and launders money from illicit sources such as drug smuggling. The 'Ndrangheta Mafia invests the money earned from drugs in various sectors, particularly construction, transportation, and logistics, the restaurant and hospitality industry, as well as agribusiness and other key business sectors. The investments of the mafia do not create economic prosperity. Instead, they create unfair competition for honest entrepreneurs. Mafia-controlled companies have a lot of money from illegal sources, which enables them to offer very low and apparently convenient prices. 'Ndrangheta-owned businesses unfairly compete with honest businesses. The mafia distorts the rules of free competition and free market. 'Ndrangheta undermines honest entrepreneurs. 'Ndrangheta harm entrepreneurs and even their employees. 'Ndrangheta controlled companies usually exploit workers and do not respect their rights. Unfortunately, there are still who think that the mafia is a phenomenon that only concerns some economically disadvantaged areas. In fact, the mafia is a problem that increasingly affects the wealthiest areas in the world. When 'Ndrangheta mafia originated in poor areas, but today it invests in the most prosperous areas. Today, the tools to block the illicit investments of organized crime in key business sectors are there. It is important to block them because 'Ndrangheta investments do not bring economic prosperity. Instead, they undermine all honest economic operators. To control organized crime, the use of cash must be reduced. It is important to encourage economic transactions through digital payment methods that can be tracked, such as credit cards, prepaid cards, and bank transfers. Accepting cash payments for large amounts facilitates money laundering and corruption. Corruption operation by organized crime, mafias, and terrorist groups. In addition to my method of investigation useful for criminal investigations, I've also identified some indicators which were the result of a specific research project that I'm going to explain later. These indicators are useful to see the signs of a business being potentially funded by the mafia and to understand when a business launders money. Thank you for your attention.
Thank you for that very insightful explanation of how we can use data. I think not just to, I guess, at least for me, I see sometimes the amount of data as being a vulnerability for privacy and in many ways, but it's also, I think, an important tool for trying to see the different ways that organized crime can be affecting our communities and making those investments with their criminal proceeds that continue to prey upon our communities. So I think that's very, very helpful to understand. And I'd now like to turn to Jean-Pierre Brun. In addition to sort of harmonizing international standards and using sort of innovative techniques and direct cooperation between law enforcement authorities, I think it's important for us also to ensure that our partners in other countries are not vulnerable to some of these threats, so that we collectively can combat these transnational crimes. And that's an area that Star and Jean-Pierre Brun have worked in for many years. So I'd like Jean-Pierre Brun to please tell us a little bit about how Star and the broader international community are addressing the challenge of recovering the proceeds of grand corruption in particular.
Thank you very much, Dan. I'm very happy to be here today to discuss about these topics on which we have all worked all our life, actually, all our lives. And actually, I had a special thoughts when I was hearing Dr. Buzz and Mr. Minari about both the European law on arrest warrants and the 'Ndrangheta, because it happens that when I was a young prosecutor, 25 years old, it's very old now, I was prosecuting, it happened to me that I was prosecuting 'Ndrangheta members in Marseille, in the south of France, and they were here in Marseille, arrested under extradition mandates, warrants from Italy, and I had to apply the still. I think the European arrest warrant was not completely in force at this point, and I was applying the old laws on extradition, which was kind of very complicated. So but we managed to send back these professionals of organized crime in Italy, where they belonged. So thank you very much. For the STAR initiative, the Stolen Asset Recovery Initiative, you have noted that it is a UN ODC World Bank initiative to help countries recover stolen assets, proceeds of corruption. So what do we do? I'm going to try to not to be too long. What do we do to help? We are first, our number one priority is to facilitate international cooperation, including operationally in the context of cases. We are not only an organization that thinks about global issues, but this initiative is specifically used to help countries in actual cases, facilitating international cooperation. It means organizing meetings that are sometimes multilateral or bilateral meetings between requesting jurisdictions and requested jurisdictions, so that the prosecutors and the investigators can discuss the cases. We try, of course, not to interfere in the conduct of the cases, because we are not a law enforcement agency, and we are not a government agency. We are an international organization whose mandate is not to get involved in investigations, but we try to do this facilitating work, and we have done it, for example, in Tunisia, in Egypt, in Ukraine, in Sri Lanka, in many other countries. And actually, there is a lot of need for trust, for investigators to be able to discuss together, and as a third party, we can bring sometimes distrust on the table, so that exchange of information can be facilitated. And the mutual legal assistance process, as you know, sometimes can be very lengthy and complex and full of challenges. And we are trying also to make sure that there is no that nothing is added to this burden of mutual legal assistance, which is a complex undertaking. Other actions, of course, capacity building, apart from international cooperation, capacity building. We are training a lot of prosecutors, investigators, and government agencies on the techniques that need to be used in investigative work and in prosecution. And we are also producing a lot of knowledge products, advisory and analytical products to provide professionals and policymakers with the tools that they need, specifically in developing countries. So that's the main areas where we are working, and we are trying to promote as much as possible innovative innovative action for some topics that are high on the priorities of the global agenda. For example, beneficial ownership. We have discussed the beneficial ownership registries. We are trying to provide technical assistance to countries on how to design their beneficial ownership registries or legislation. We are also working on open source investigation, the use of data. Actually, in Tunisia, when we were called to to help the new Tunisian government after the fall of Ben Ali regime in 2011. One of the action that we have conducted is to help the Tunisian investigative judges and prosecutors put together databases. I'm thinking about what Dr. Minari explained, and definitely, even if it were not very sophisticated tools, it was tools that were made a little bit on the job, it made an enormous difference for the prosecutors and the investigators, because they had a lot of data specifically about financial transactions that they could not use very well because they did not know how to do it, and so we managed to do that, to help a little bit on that. Okay, I can maybe stop here. Thank you.
That's great, and I look forward to talking a little bit more in the next round, I think, about some of the lessons from the Arab Spring and the international community's efforts to respond to those changed circumstances. But now I think, now that we've heard a little bit about some of the developments over the last few years, I think it would be useful to see what are some of the challenges that we are facing now, and some of the types of things we can do to look out for some of these threats. And certainly the BKA has an enormous insight into what some of these challenges are that we're facing now, and so that maybe we have a little bit more sensitivity to that. I'd like to turn back to Ms. Link to ask what the BKA's in the BKA's view, what are some of the biggest challenges that we face these days in prosecution of transnational offenses and terrorist financing, money laundering, organized crime, those types of things?
Yeah, thank you, Dan. I'd like to focus on money laundering and terrorist financing, because the field of organized crime is a real big field with a lot of hinders and a lot of problems to investigate. Within the area of money laundering, I think the main problem is that we have very often problems to prove the predicate offense of money laundering, especially when we have to work with countries abroad where we don't get responses, where we don't get sufficient responses. And this is one of the main problems. And as I told, we have now this all-crime approach in Germany, but still the judge has to be convinced that the money is illegal, that it is incriminated, which means the object to be laundered has to proceed from or has to be the product of a crime, and we have to prove that, and that's very difficult to prove. With a view to terrorist financing, the main problem is that we have to clarify the final use of the funds which are transferred abroad. We need to prove that the organization who received the fund at first, in fact, has received the money transferred, and in second, it is classified under German law as a terrorist organization. And very often we can't see in detail where the money flew. For example, if there are transfers to Syria or to Iraq, we don't have the possibility to clear and to check where the money has gone. Has it really gone to a terrorist organization, or was it a kind of humanitarian aid? And it's very difficult to prove that. In general, we already mentioned, I think the lack of international harmonization is a very important fact. Because if we don't have common standards and common legislation frameworks, it's quite difficult to connect and to have a successful international exchange on information. Additional, if you need mutual legal assistance or things like that. If we look at our national risk assessment we made in Germany, I would say that all areas where there are possibilities of anonymous transactions, those are the fields which have the biggest risk for money laundering. So that, for example, if we have in Germany a very cash-intensive industry, we have no limits of cash transports. We have cash couriers, we have cryptocurrency, there are prepaid cards, and of course there's Hawala banking, where there's no supervisory agency looking for any regulation. The field might be interesting for our participants is the section of the cross-border corresponding bank business, because it's this correspondent bank business makes it possible to conceal payments to offshore territories. This risk arises from a lack of supervision of banking in the home country of the bank, for which a corresponding banking relationship exists. And if we have transfers to offshore centers, we face the same problem in international cooperation, that we don't get any answer.
Yeah, well, there's certainly a lot in there, lots of challenges that we face, and it's interesting to hear you talk about the terrorist financing as opposed to money laundering. They seem to be very different challenges. On the one hand, terrorist financing, it seems almost a disruptive objective, trying to intercept something before something bad happens, whereas money laundering is very much a forensic effort, trying to understand where the criminal money comes from and being able to prove that. And certainly in the international corruption context, where I spend most of my time, that's one of the biggest challenges, is getting that evidence of the predicate conduct, especially if someone's been in power for 20, 30 years. That can be an extraordinary challenge. So those are key challenges. I think maybe, Mr. Minari, you can explain some of the red flags and indicators that you've seen that maybe help us identify when there is a potential business investment funded by the Mafia, or how perhaps the Mafia exploits current crises like those due to the pandemic.
Yeah, I've identified some indicators. These indicators are useful to see the signs of a business being potentially funded by the Mafia, and to understand when a business launders money. These indicators I've developed classify warning signs that are useful to reveal the economic investments of organized crime. The follow the money principle is essential, but other elements must also be considered. I've classified the warning indicators of a business being potentially funded by the Mafia into 5 categories. I will be briefly summarizing these categories of indicators to respect the time limit. The indicators I will mention are based on the study of numerous court cases I work on directly. The indicators belonging to the first category deal with sudden and unusual transaction. The second category includes indicators dealing with suspicious changes, unusual mergers of companies, unusual bankruptcies, and many other useful elements. The third category includes indicators dealing with corporate structure and governance. The fourth category includes indicators dealing with prevention. Finally, the fifth category includes indicators dealing with tangible signs. Tangible signs such as for construction companies, the outsourcing of work to other companies that should not be present on the building site, as they have connections with organized crime groups. The numerous indicators grouped here into 5 categories for the sake of brevity make it easier to identify Mafia's investments in business sectors. The indicators are the result of a study and the analysis of numerous cases of organized crime especially the 'Ndrangheta Mafia in northern Italy and Europe. The Mafia operates through corruption. In my investigations, I've dealt extensively with corruption cases related to organized crime. The 'Ndrangheta Mafia corrupts by offering money or corrupts more and more often without money, but by offering civil servants holidays, houses, sexual services, or other benefits. Moreover, in Italy, some people belonging to the 'Ndrangheta Mafia try to influence also during pandemic, not only some public institutions, but also some municipalities in northern Italy. One of my investigations was mentioned in the fourth paragraph of an official report regarding the dissolution of Brescello Town Council, the first municipality dissolved due to mafia infiltrations in Emilia-Romagna region in northern Italy. A few weeks ago, President of the United States Joe Biden published an important document on corruption whose title is very clear: Memorandum on Establishing the Fight Against Corruption as a Core United States National Security Interest. President Biden's memorandum starts with the following statement. It has been estimated that acts of corruption start within 2 and 5% from global gross domestic product. Anonymous shell companies, opaque financial systems, and professional service providers enable the movement and laundering of illicit wealth, including in the United States and other rule of law-based democracies. According to President Biden's memorandum, it is necessary to support and strengthen the capacity of civil society, media, and other oversight and accountability actors to conduct research and analysis on corruption trends. And so these words are very clear. And I also really appreciated the reference to civil society, also because when I started my investigations on the 'Ndrangheta and other criminal organizations, I was simply a student. I was a law student. And so I think also in Europe, this is important. The 5th EU Anti-Money Laundering Directive requires increased interconnection of databases in different member states, which is essential to easily identify the signs of money laundering and corruption. The new European regulations of Eurojust and OLAF, the European Anti-Fraud Office, also aim to facilitate the exchange of information. Databases and open source information must be cross-checked strategically, and to do so, it is essential to know how mafia's new ways of operating and how it is changing. Thank you.
Thank you. I think that's a great summary of some of the things to look for. I think certainly in our practice in anti-corruption, the role of investigative journalists and civil society in exposing some of the threads for law enforcement to pull on is really crucial. And I think your presentation also sort of highlights some of the difficulties in that there are vulnerabilities at the very local level and at the national level. And with that, I'd like to turn to Dr. Bose again to ask how legislators and law enforcement authorities can deal with this wide range of threats. And at the same time, they have a very broad international obligation to combat money laundering. So what do they do to prioritize within this this very broad mandate and the wide variety of threats?
Yes, thank you. I think I can come back to what Ms. Link has already said. In combating money laundering, we are facing a dilemma. On the one hand, the moral wrong of money laundering is inextricably linked to the predicate offense. So there is no crime without this link to the predicate offense. But on the other hand, there are huge difficulties to establish this link to the predicate offense, at least if we have complex cases with a transnational dimension. And this has led to a wider and wider scope of the offense of money laundering, the all crimes approach, where we take in minor offenses as a predicate offense as well. And this even escalates or, well, leads to greater difficulties with the bottleneck of limited resources in personnel and also financial resources of law enforcement authorities. So, and I think this is a great problem, which should lead to a reconsideration of the wide concept of money laundering we have right now. And of course, these difficulties also put under pressure traditional procedural guarantees, such as the presumption of innocence as well. So I think the focus should therefore more be on the money itself, the confiscation of assets, because if we construe the concept of confiscation in a manner that is not close to criminal punishment, we will have another level of proof. We can lower the standard of proof. And of course, we do not necessarily have to comply with all the procedural safeguards that apply in the framework of criminal proceedings. And Ms. Link has already mentioned this new institute of independent confiscation, which is a form of non-conviction-based confiscation in German law. And I think that's something that might provide an instrument to make progress in this field. Thank you.
Thank you. Certainly, non-conviction-based forfeiture or confiscation is an important tool in combating transnational crime. And with that, I think that's a good segue to talk with Jean-Pierre about the Arab Spring and the efforts of the international community after the Maidan in Ukraine. There was this great outpouring of effort amongst the international communities, both the public sector and in collaboration with the private sector, to try and see what could be done to recover the proceeds of corruption from the years of dictatorship in the Arab Spring countries, as well as the corruption in Ukraine. But unfortunately, I think we haven't seen as much of a result of that. And so maybe very briefly, so that we get a little bit of time to conclude here, Jean-Pierre, could you tell us what you think some of the quick nuggets of lessons learned from those efforts in asset recovery are?
Thank you. The quick nuggets in 2 minutes, something like that. Okay. In various cases, Arab Spring, Ukraine, and other countries, Sri Lanka, what we have seen is when asset recovery action starts, generally because there is a change of government, there is a lot of information that goes into law enforcement agencies, financial intelligence units, tax agencies, and other agencies. The main issue is how to use this information, and so that's the main the first obstacle, I would say, which is that, for example, I come back to Tunisia. I mean, immediately after the fall of the regime, of course, not before, the banks decided to do a lot of suspicious transaction reports. And suddenly, the financial intelligence unit in Tunisia and the law enforcement authorities were drowning into stacks of papers or into electronic files about transactions in the last 5 or 10 years before the fall of the regime. So the question is how you can use this information. Once again, it is not obvious because you need to build a case. I mean, this is the first this is the first step of building a case, getting the information on a transaction. And then, so suddenly, after years and years of doing nothing, the private sector decided to give a lot of information to the public sector, and the public sector, after doing nothing for years as well, started from scratch to work on all these transactions. So the main obstacle that you have is that you cannot deal with the flow of information. You have to prioritize what you do, what you pursue, and it takes years and years to do that, actually, because you don't necessarily have the resources to do it quickly. You can try to be more effective by using modern technology, databases. Maybe now you can use new tools like artificial intelligence and deep learning to go into the transactions and to see what happens. But still, the point is that it cannot be effective, and at least very quickly, when you start from scratch after years and years of doing nothing. So I think, yeah.
If I apologize, I think I'm going to have to stop you there.
Okay.
I think that's very insightful, though, because I think dealing with the volume of data and trying to figure out what is actionable is really a major challenge, particularly after a change in government, so that it's been so stark. I want to first of all thank all of the panelists, but ask them if they could, in 1 minute or less, give if there's one thing that they could say to our colleagues in the private sector who may be listening to this discussion, what they can do to support our collective effort to combat transnational crime, because it affects each of us, both as public officials and in the private sector. What would you say? What recommendations or message would you like to convey? Again, in 30 seconds to a minute. And once again, please, Ms. Link, if you could lead off.
So there's one special wish or thing I would ask to the finance sector. We miss common technical standards, which we think that they are needed for the required transmission of transaction data by those financial institutes. There are no harmonized bank statement formats, something like that. And this missing electronically analyzable format leads to a delay in the analysis of the information and leads to delay in the exchange with other law enforcement companies or other institutions, especially abroad. So there had been a working group to find a way how we could work with that, a recommendation given to the European Commission. And we hope to get support for the implementation of this standardized format and hope for the support of the financial sector too. Thank you.
Fascinating. Dr. Bose?
Yes, thank you. I'm not an expert in the banking sector, but my focus my wish would be that we, even if cooperation between the financial sector and law enforcement authorities is quite important, that we have a strict division of tasks and responsibilities in that field as far as combating money laundering is concerned, which is, of course, a matter for the law enforcement authority. Of course, there are obligations, but I'm a little bit afraid of privatization of criminal investigation, and that's something, I would like to avoid. So thank you.
Yeah, certainly very important and challenging as banks try and implement their own obligations to detect money laundering. We don't want them to become surrogates for law enforcement at the same time. Jean-Pierre? Oh, you're muted still.
Thank you. That's the best way of ensuring that I will not pass my time. No, I will just follow up on what I was saying. I mean, let's try to focus on some topics. I would say that I would like to encourage the private sector, and actually not only the banks and the financial institutions, but also lawyers, accountants, and all the people who do contracts and legal arrangements, specifically to organize beneficial ownership, beneficial ownership arrangements. I would encourage these institutions and these professionals to have both technological tools to check and to record their clients' activities, explanations, and background, and also human resources that would complement these tools in the way of having business intelligence for institutions that can afford it, having business intelligence services to take the information.
It sounds like focusing on investing the resources both in personnel and technology to focus on beneficial ownership. And then finally, Mr. Minari, again, very briefly, apologize for the lack of time here.
Yeah, the European Public Prosecutor's Office will be important also to carry out checks on reports by banks, and it is important to encourage economic transactions through digital payment methods that can be tracked. Thank you.
Yes, thank you. And I think Ms. Link mentioned earlier the importance of trying to find a way to apply the travel rule to these emerging financial transactions. So it's certainly exceedingly important. Well, once again, I really appreciate everybody's time here, both the panelists and the participants in the audience. And I hope that this discussion has been as rewarding for each of you as it has been for me. I've certainly learned a lot, and I look forward to the new innovations, both in public and private collaboration in combating transnational crime. Thanks again, everybody.